We got almost 40 participants, and who's going to start first, me or you?
I'll go ahead and welcome everybody. So thank you, everyone who has joined. This is the Brilliance in Commerce and House of Freedom Trust webinar for February 7th, 2018. And we wanted to thank those who attended our past ones for your patience, because we are just learning the Zoom system. And I think this time we'll be successful in a few improvements, such as enlarging Randall's face many more times throughout the presentation when he's speaking, rather than just giving you graphics on the screen. Plus, we have a lot of new graphics. We got rid of the squiggly lines. So I think we're working through this, and thank you for bearing with us as we master this wonderful system. And we can go to the next image. So, Brilliance in Commerce, as everyone may know, is a project of La Vérité. La Vérité means the truth in French, and that includes House of Freedom International Natural Law Trust, Liberty Debt Elimination System, and affiliations with special offers from time to time. We have things like wealth from your FICO score, credit repair, gold purchasing concierge, offshore asset protection, Monaco Management Group, wealth management, cryptocurrencies forthcoming, information on a lot of interesting things. Next. So I am Tansen Famrat, founder of Brilliance in Commerce. I have been made the member of Board of Advisors of Monaco Management Group. I've been a speaker on radio shows, and I'm former offshore investment seminars worldwide, and author of Sovereignty Consciousness, as well as a number of different, well, a forthcoming book, Cosmic Renaissance, and so forth. So Peter, we lost your screen sharing, so I don't know if your power went out, but Randall, thank you for being here. And I wanted everyone to know, while Peter's getting the screen sharing going back, that I have been so grateful for the amount of time that you have been devoting to our clients and to these webinars. You don't have to do it. It's something that you've done out of the vast experience you have with trust and the kindness of your heart. And the fact that you have been, I just want to say to everyone, more than professional, you have also been a harmonious being with regard to your relationships with people, patient, understanding, forgiving, kind. And these are qualities that are needed in business as well as in law and in asset protection, as well as in everything on this planet, as you know. And that has been everyone's experience with you, and I just wanted to thank you for being that way and let everyone who is new to this know that if you haven't already had the privilege of being involved as a trust client, you may find that this is a real asset, is having that kind of consultation. So, Randall, please go ahead and share a few words, and I'm going to privately go and see if we can get our slides going again.
Oh, thank you, Johnson. Geez, we've known each other for almost 30 years, and we've been in and out of business adventures together, and I've been working in the field of trust since '85, and had really good mentors along the way, and we connected up again, I think, in the '90s, and we said, let's do an associate, work this together. You do the amazing marketing work that you do, and I'll just take care of the clients. And one of my joys about doing this is meeting new people on a sometimes daily basis. New clients come in, but at least certainly on weekly and monthly basis. And once we get started, it just goes from there. And sometimes people don't quite understand, so we email and we talk back and forth until they have a good handle on how to make trust work for them as far as protecting all the assets. Now, on our first webinar, I gave a general background of what a trust is, which is basically a contract between 2 or 3 people. And it's your unalienable right to contract. This is not a statutory process that you have to go beg the state for. This is your ability, especially in the U.S. and all countries that honor the common law, that you have a right to contract with anybody or anything. So I talked about how to start it and put it together, and where do you go from there? And then the second show, we talked about the position of the trustee, what he's supposed to do, what the duties are, what the purpose is, where the power lies. And it's incredible or important that you need trustees, one of them which is non-related to you, so that there's a separation between you and the asset. You can buy a revocable trust online for about $200, and you can be the grantor and the trustee and the beneficiary, but it doesn't keep the asset separated from you, and so it's always subject to loss, just as if you owned it yourself. And so by having a private irrevocable trust that we set up for you, you have that separation. And then that separation gives the title, legally putting the asset into the trust under the ownership of the trustees who take care of it and protect it for your benefit. That's the most critical part of the irrevocable trust. So that's the idea. And today I want to just touch briefly on the beneficial interest and what it means to be a beneficiary and the different combinations that can happen so that you can have a very safe asset protection program. So what happens when you become a beneficiary? There's multiple ways to do that, but primarily when you are the grantor, the creator of the trust, typically you are also the beneficiary, or you may be one of the beneficiaries. So you may create a trust in which you are the grantor and you have children and grandchildren, or you have friends that you want to have as beneficiaries, and we can do that. And that's part of what I'm going to talk about this afternoon, but that's the idea, is for you to take the asset, put it in trust. Legal ownership belongs now to the trustees, but the trustees are under a fiduciary responsibility to enhance and protect that asset.
All right, Randall, thank you very kindly, and thank you for keeping us going while Peter got the slideshow going again. We were still in the beginning, but let's catch up with you. Here is the presentation of the dates. So we have February 7th is today. March 7th, everyone, is the next one, and then April 11th. And we can go to the next slide. And here is for future webinar attendance, links and numbers. If you haven't already, subscribe to the Brilliance in Commerce newsletter published by La Verite at houseoffreedomtrust.com with dashes between each of the words. Click on more and then newsletter sign up. You can also go to brillianceandcommerce.com and go to the bottom of the page, and you'll see the newsletter sign up there. And then we have the phone number, 360-200-7521 is our company phone number for people who need to speak by voice and have questions that cannot be answered by email or reading the website. Next. International Natural Law Trusts. So Randall was giving you a little introduction on beneficiaries, but let's get an overview of what these trusts are about, especially for the newcomers and even those who are already familiar with them. It helps to be reminded that this is how the cultural creatives, we like to use that phrase because really we're looking for those who are peaceful to use these trusts, change makers, conscious wealth managers, contributors to a golden age, are quietly transacting sacred commerce through an advanced asset protection instrument, previously a best-kept secret of the super rich. The Kennedys, the Rockefellers, these are well-known families in the past that have used the same principles upon which the trust design and construction that Randall uses has evolved. So peaceful people, and that we distinguish from those who are involved in dangerous activities. For example, if you were out in the middle of the ocean in a Greenpeace ship trying to bring environmental radical changes and you're being shot at, and you have your assets in a trust that is likely to be attacked by enemies, it's a lot more likely that there could be problems. But generally, we have had zero problems at all in 3 decades of use because most of the people we attract are those just living their lives quietly. They just want to stay out of harm's way, protect their assets. And one of the reasons I like Randall and what he's doing is that he's kept everyone out of trouble if they follow what he gives them. So peaceful people can benefit from operating one or more of these trusts, which concentrate the best asset protection secrets of the elite into the fewest words and simplifies the language so as to minimize legalese, that's important, and maximizes common politeness and understandability. That, ladies and gentlemen, distinguishes this trust from most of the others out there. These trusts can be operated in most countries, anywhere in the world. Trust clients may become either trustees or creators, beneficiaries, and managers. And you'll find today that the word creator is synonymous with settler and grantor. These international pure natural law sovereign irrevocable trusts have no income tax filing requirements. They are infinitely flexible and can be adapted to any ethical, lawful, and noble purpose. They have a 100% success rate, meaning they have never been penetrated or invalidated in over 3 decades of use. This has been the trust of choice for those preparing for the global currency reset as the best vehicle for holding wealth and for preparing one's estate for generations to come. Heirs can be endowed with successorship seamlessly with no time delay, no probate, and no death taxes. Thousands of fortunate clients are quietly happy with these trusts. I want to just give you a brief introduction to Randall, who you've had a few minutes of listening to. Randall Hillner is Director of Trust Department here at Brilliance and Commerce, the founder of House of Freedom Trust, White Light Unlimited, trustee for One People's Public Trust, and creator of International Natural Law Trusts. And I must say, a very good friend, someone I respect greatly, and I think everyone who has dealt with him as trust clients has really appreciated his love of his work, his knowledge, his expertise, and his ability to not only consult and guide and direct and craft excellent trusts and guide people in the excellent operation of them, but also to show human qualities that make him harmonious and enjoyable to get along with. Randall, would you mind giving us just a couple-minute recap of the last one before we proceed into today's topic, the last webinar in January?
Sure. I think I touched upon it earlier, but basically we talk about the duties and powers and authority of the trustees and what it means to be one, the responsibility that it takes to be a trustee, and the work involved on how to protect and enhance the assets. Some people have an asset and they just want to separate it out and get it out of their name and have it in the name of the trust for either their benefit or for future beneficiaries. And powers and authority are pretty lengthy, and I don't want to go into all of them. You can go and get most of that from the last webinar, but basically the trustee is the one that takes responsibility for the assets. Now, which is going to lead us into our today's process about being a beneficiary. But we talked about how you can be the grantor, and then you can't be, if you're going to be the grantor and the beneficiary, then you couldn't be a trustee. You need to have either two friends or one friend and one family member can be a trustee. That's one way to do it. Sometimes people say, well, I really want to be in control of my assets, so I'd like to be a trustee. And you can do that by having a friend be the grantor, and then the assets can go in the trust from anywhere. And then you as trustee would need another co-trustee that's not related to the grantor or the beneficiary. And some people want to be a sole trustee with a successor trustee in case something happens to them, which is also possible. But that means you can't be beneficiary of that trust. So that's only when you really want to control your asset and you want it to go into the future generation or to present time other endeavors. In other words, you may have a number of humanitarian projects that you want to support, other people that you want to support, and so that's when you could step in as sole trustee, and that's fine too. You just can't wear all the hats. You have to give up. There's three hats: the grantor and the trustee and the beneficiary, and you can't be all three. You can only be two maximum. It's best if you're well, it just depends on what you want to work at. Early clients that we had in San Mateo, San Francisco area were mostly retirees, and they wanted to take their asset and put it in trust and have the trustees basically take care of it. They could be, the grantor can be the manager. In those days, the banks would allow the manager to be also a signature on the account. And today, since the banking laws have changed, and and I won't even get into that conversation, but basically now most banks will only let the trustees be on the signatory card. So their name is going to be on the checking account and the debit card or credit card that you get with the trust is opening up a bank account. So that means, like, one of the important things is that I have to keep reminding clients is that when you go to the bank to open up an account, you need to have your trustees with you because the bank often will just flatly tell you, no, we don't want to have your business because you're not a trustee and you can't sign. So if you are going to go to the bank and open up an account, then you need to make sure you take the trustees. So and what the power is, they have the power to do pretty much anything they want as long as it's a legitimate contract that they enter. Buy and sell pretty much any asset, invest in anything. It's just legitimate. And that comes basically from a long time ago. Trusts were set up by the early crusaders who had a substantial estate in Europe and were going into the Crusades and didn't know whether they were going to make it back. So they took their property and found their closest friend who wasn't going and said, I want you to look after this estate and take care of my children and family in case I don't return. So that's how the first basis of the trust started to come into being, and it's gone and evolved ever since then. And obviously, as Tonson said earlier, in the early days, some of the early political power figures created trust. Entrepreneurs in the early 1900s, Rockefellers and Kennedys, et cetera, all had trust, numbers of trust. And you can yourself create a trust, and the trust, then the trustees can say, we want to break this asset base into 3 or 4 separate trusts. It may enlarge itself so much that you break it down and you start all over again. You have to get new people to be trustees, but that's how you break your assets up and keep them all separated out so that they're well taken care of. And like more beneficiaries may happen, your children may have lots of children and lots of grandchildren, and then you want to create either a trust for your grandchildren, or you want each of your children to have a trust and let them go about separating the assets as well. So that's what the trustees' duty responsibilities are.
Thank you. This is sounding like more than a recap, but also a great overview as well. Did you want to give more in the way of a general commentary before we go into today's material?
No, I think we're ready to go. Everybody here that's on the line can go and look at the first 2 webinars and get a lot more information. And then if you do have a trust with us, then you certainly probably already have my email, and I've talked to a lot of you people live on the phone, and I've actually done some Skype calls with a couple of the clients, so it's not a problem. Okay, so today what we're going to talk about is trust certificates. There's only 100 units in the whole process, and it can't be more than 100. So the amount that each person has depends on how many beneficiaries there are. If you are the sole grantor and the sole beneficiary, then you would have all 100 units, and then you would have trustees be giving you beneficial interest on a monthly or quarterly or yearly basis, depending on how large the amounts are. So it's very simple, and it can be broken up easily. And if you want more or less, beneficiaries change, trustees sometimes change, beneficiaries will die, etc. And we'll get into that. So next slide. Lawful ownership. Okay, so whoever's name is on, it comes with each trust certificate is given out. There's a Schedule C in the trust document. Schedule A is for personal property. In other words, you might have jewelry, you might have artwork, etc. Schedule B is for real property, where you put your house into the trust and it goes into Schedule B. And then Schedule C are the number of beneficiaries. if you're a beneficiary, then and it's recorded, then you're the lawful owner of that beneficial interest. But ownership means that you just own the right to receive the benefit of the payout on the assets that belong to the trust. Some people just have a house in trust, and somebody has to take care of the mortgage and the insurance and the upkeep. And the trust will do that, but that means you have to have the trustees open a bank account, and then they cut a check, or if you're the manager, you can do the daily business of the trust. But eventually, when you pay your mortgage or you pay your insurance, then the trust pays for that, and trustees will probably have to sign if the bank doesn't allow the manager to be on the account. But then, so if you do that, then it's only fair that you would pay an equitable rent to live in the house that's owned by the trust. And that rent basically would go to pay for the property tax, the mortgage, the incidentals, the need to keep up the safety of the house. There's no suit against anybody, nobody falls down, etc. That's so you own it. You own the benefit, but that's all you own, is to get the benefit. Next. Transferring. What that means is the certificate holder cannot just give his certificate away. What you do if you want to transfer your certificate to somebody else, or maybe you want to give your part of your certificates. Let's say you have 25% of certificate, 25 units of the 100, and you want to give some to your children. Maybe they're going off to school and you want to support them. Then you would go to your trustee and you would say, I want to take these certificates and I want to transfer it to some of it to my children. So the trustees would take it back and they would register it in part of the trust document. And they say you take your 25% and you give 5% to two children. Then you would get a new certificate that would say you only have 15 units, but then there's a record that each child has 5 units of beneficial interest. And what the trustees do to be able to make that happen is they just take the certificate back. There's a new minute made indicating the intent of the certificate holder, and then they cut new certificates on the amount of how much you're getting back and how much each child gets. And then they nullify the trust certificate that you've had. It's kept in the record book, and the record book now in the minutes will have the new number of units to go to each beneficiary. And the trustees, they handle it by just rewriting it, making a minute, keeping a note, and making it part of the trust document. Now remember that the minutes, we haven't talked about that a lot yet, but the minutes are private. When you go to the bank may want to see the whole document. That's what a number of my clients are saying now whenever they go, is the bank wants to see the whole document, and that's fine that they do that. If you can get it, if you don't have to give it to them, fine, but they want to see that it's a legitimate, there's a whole document there. So you can give them the documents, but you would take the minutes out because that's your private personal business. Next. Okay, Peter. All right, now here's where we start to get a little technical. Is trust certificates cannot be encumbered. In other words, uh, the beneficiary is only allowed, he can't take the trust certificate and encumber it. He can't use it for a loan. He can't sell it. He can't trade it in. He can't do anything without the permission of the trustees. And so if he's going to do anything like that, he has to go to the trustees and um, make the changes. Now, he can go to the trustees and break it up, and he can go to the trustees and see if there's uh, anything that can be done. But basically, trust certificates can't be encumbered. You can't take a loan on them. You can't use them to hypothecate. But that's what keeps, because they can't be encumbered, that also keeps anybody coming after those certificates. In other words, there may be a debt that's owed. Those units can't be encumbered with the debt. They're free of that. So that's how that can be done. And so the beneficiary has the enjoyment of the beneficial interest, but he cannot just use that like money. Next. Yeah. So here we are. We've talked about this. The legal owner of assets in the trust belong to the trustees, not to the certificate holder. The certificate holder just has the right to receive benefits of the trust, and he can't use it frivolously. In fact, we have a spendthrift clause in our trust document that keeps the certificate holder from exploiting those trust certificates for his more benefit than he's actually owed. So the ownership belongs to the trust. He has lawful ownership of the beneficial interest, but he doesn't own them himself. Next. The creditors have no right. Now, there are a few examples that are different, but the attachment of certificates can't be done from an outside source. Now, any creditor or anything like that can't be done. Now, there's also a 2-year process. In other words, if the creditor already has an action against a debt that you owe to them, then you can't just go and put your property into trust and escape, especially if there's an action already, because they can go to court and get that it's that you did it in a sense to commit fraud and avoid the creditor. So the ideal is that you're going to take the asset and make sure that there's no action against you in any form, and then the asset can be free from your ownership, and nobody can, then the creditors can't get attachment to the certificates. Okay, next. The certificate, it's simple. We talked about it before, that on the death of the certificate holder, the certificate would go back to the trust, and you've already probably worked out the way that you want the amount of the trust certificates that you hold to be given to others. So that's all that is. In other words, it doesn't, even though you're the single beneficiary or the single grantor, the trust doesn't fold upon itself. It stays alive and it continues to go. There's no probate on anything in the trust because it's not yours. So there's nothing in the estate that would go through probate that belongs to the trust, which is not in your name. You're only a beneficiary, and the death of the beneficiary, the certificate goes right back into the trust and then is given out to other beneficiaries, either future beneficiaries or divided up equally to the other holders that are already still there, and it goes on like that forever. Next. All right, I just explained that. It has no effect on the changing of the trust. Now, the only time that you're probably going to change that is if you're the only beneficiary and there's no children, and you have no minute indicating where you want it to go, then the or let's say you have grandchildren or other people that you want to give it to, you may have a list of places that you, in the event of my death, I want the remainder of the trust to go to charities, to things, humanitarian projects that you want to do. And the trust can either go on, the trustees can decide to continue the trust. And then sometimes there's so many beneficiaries that trustees say, okay, they send a letter to, let's say your family gets so big, you have children, grandchildren, great-grandchildren, all of a sudden there's 100 beneficiaries. Then the trustees can say, hey, this is getting too big. We're going to send a letter to each beneficiary and say, do you want to keep this going, or would you like to take the remains of the estate and then make your own trust down the line? And then, so on a pro rata basis, if there's 100 people in the family, then they may all get 1% of what the asset is valued at, and then they go and deal with it as they want. They can either create another trust, or they can all get together and say, no, we want to keep it going and we'll get some more trustees. But typically, if it gets too big, you either break, the trustees say, okay, we got to break this up a little bit, and so we're going to create a couple more trusts from where we are now, and you're going to start all over again. So it may take the fact that there may need to be 5 or 6 trustees if the estate is rather large. Like I'm sure the Kennedys and the Rockefellers have more than 2 trustees, but that doesn't matter. It's like, it just depends on how big your estate is and what you want to do with it. It's really the choice of the grantor. uh, and how the estate is kept going or dissolved at some point in the future. But it can be renewed. It won't dissolve for 21 years. And then at the end of 21 years, the trustees get together and they ask the beneficiaries and or the grantor if they want to do another period of time where the trust stays intact. Next. Well, the rights of the certificate holder, he can only make sure he doesn't have a right to badger the trustees and demand that he wants more or he wants to change it. So he can't go in there. All he has a right to do is to demand that the trustees pay him the percentage of his certificate. So if he has 25% of the assets in the trust, then he can demand that the trustees make sure that he gets 25% of the outflow of the trust. It may be an estate, in which case there's no cash flow going out, and all the certificate holders would have to get together and say, we would like the trustees to sell this piece of property and convert it to cash or gold or whatever the currency is at the time, and then they would distribute it out to each beneficiary or certificate holder. It doesn't really matter. So the holders would know when the trust document is signed, they can ask the trustees to give them what they can have, what their rights are, and what their limitations are. And that's usually explained in the beginning. Like I said, when we first were in Marin, it was mostly retired people that put their estate into trust and turn it over to the trustees so that they could just live on the outfall of that asset. So they can demand to know what their rights are, but they don't have the power to tell the trustees what they must do. Okay. Questions? I know that was pretty quick. We're trying to keep this short, and it's better if you've been watching that if you have questions on that, now's the time. Let me say, I don't know how you would do this, Tanzan, but how many of the participants, looks like we have 59, 60 participants, how many of you have House of Freedom Trust already? Is there a way for people to raise their hand on that or send in a way to account for that, Tanzan, Peter? Hey, aloha, Steve. Okay, good. Well, how many of you are new then? Do you have any questions, Saroni? I just saw that flash by. Okay, good. Any other questions then? Oh, so we'll have a quiz tomorrow. Go ahead, Steve. Allison, you mean your questions are written down? They're probably going to be recorded as I answer your question. Steve, you had a long question. Tonson, do you have that available? I don't know how to get this chat up. Let me see if I can pull this up. Yes, okay, there's a question from the grantor could also be the manager. Uh, is this a banking law or change recent? Yeah, it was after 9/11, the banks really started to get difficult to work with. When I first was working in the Bay Area, um, you could just walk into any of the major banks and as a manager and or at least one trustee and open up a bank account right away. So I don't know why the banking laws changed. Obviously, um, there's something going on with the banking system, with probably the Federal Reserve, et cetera. But that's another seminar altogether. A pure trust, what's the difference between a pure trust? It's just the name. Um, Pure trust, common law trust, it's non-statutory trust. Um, doesn't I just try to get those terms away and just say it's a private, irrevocable personal trust. It can be used for holding assets. It can have a business. It can do any multiple things. When you get a trust and you read clearly the trust document, then you'll see. Let's see.
Can you hear me, Randall?
Yes, I can.
Okay, I don't know what happened earlier, but there's a chat question here. Why does the trust not file tax return? Is it because beneficiaries will pay taxes when they get distributions?
Yes. That's typically the case, is that the beneficiary gets the potential increase in the value of the trust, and so it's up to them to file their own tax return. And the trust basically doesn't have to file.
Let's see.
In Canada, they're in Canada, the clients that I have there, um, in the U.S., you can just go online and get an EIN number and walk into the bank with your trustees. In Canada, they have to do it differently. You have to write into the Canadian um, tax process, and it's just asking for a number, and it takes a little bit longer. They don't have it on. They don't have it online, but it's available. And then you can go into the bank in Canada and get it. Now, if you live near the border of the U.S. and you have friends in the U.S., you can have your friend be part of the trust, and you can file for a foreign grantor trust number with it and get an EIN number for the U.S. and open up a U.S. account. And probably, I don't know if they've tested it yet, but you could probably do the same thing with a bank. You can use that number for a bank in Canada, but I'm not sure about that. The trust can give a K1 to the beneficiaries, but it doesn't have to.
And then this question is, when I got mine, I was under the impression that grantor could also be manager. Is this banking law change recent? And I would just say that the question, it sounds confused. Um, it's not a banking law that is applicable here. It's, yes, you can be grantor and then quit, sign off on the trust and wear a different hat, right, as a manager.
Yes, oh, for sure. As grantor for the trust, at the end, one of the things that you're going to do after you appoint the trustees is you are going to give all power away to the trustees, and you're basically stepping aside from any formal arrangement with the trustees. And the intent of your intent of the reason why you created the trust is set. It's in the trust indenture. Then you step away altogether, and the trustees and the beneficiaries work it from there.
So it really has nothing to do with banking law then, right?
I don't know how it all works. I'm sure the IRS has really got their thumbs ripped around the banking system, basically, because the IRS is a collection agency for the Federal Reserve, and I'm sure that exists in Canada as well. That's one of the things we did for OPPT. We went to Europe, and we went to the major banks. We eventually ended up in Switzerland and went to the BIS, the Bank of International Settlements, where all national banks go, like the Federal Reserve of US, Federal Reserve for Canada, all go or under the auspices of the BIS. So it's a really complicated process. And so they have all the gold, all the money, and all the guns. And there's not a lot that's being done now. We filed a lot of paperwork with the OPPT, and it didn't seem to change things. And it's getting even tighter now. I don't know what's going to happen, but all I can say is if you have all your assets in trust, then you're going to be better off than you are if it's out there in your name. Somebody says is this a business number? It doesn't matter what kind of number it is. It's the number you're going to need, especially in the U.S. You're going to need the EIN number for opening up a bank account. It's just the way the banks work now. How did it turn out with OPPT? She's not on. Heather is not on trial for the OPPT. It's an entirely different process. We did all the paperwork for the OPPT. We filed paperwork on all the banks, on the Rothschild Bank in England, on the Federal Reserve in New York, and then the BIS in Switzerland. All it was filing paperwork under documented evidence that basically there is paper and the banks are all a fraud. And that's all I'm going to say about that. Okay.
Would you like to take Steve's question?
Steve, have a long question, Ken, but yeah, sure.
Okay. Steve, if you're there, I'm going to unmute you. You have a question? You want to speak? You're on the air.
Okay, thank you. Can you hear me?
Yes.
Yes.
Okay. Hi, Randall. Also a shout out to Annabelle and Caleb. This is Steve in New Zealand and Carlene. And we purchased a trust from you back in September of 16. And I'm assuming that's the same trust that we're talking about now, the natural trust.
Yep.
Okay, the question that I have, and I think this may help others as well, is I plan on acquiring a piece of real estate. And as it is, it's my understanding, it can be potentially a liability. Do I acquire another irrevocable common law trust and put the trust, put the property into the trust? And do I put the trust into the or what I'm going to call it is the primary trust or the mother trust?
No, I wouldn't do that. You wouldn't put one trust in the other. What you would do is you would have the first trust be the beneficiary of the second trust. So the property goes into trust number 2, and then the beneficiary of trust number 2 is trust number 1.
Oh, okay.
But
All right.
they don't. There's no ownership involved. The owners of the property would be the trustees of the trust. But I don't quite get why you need to have 2 trusts. We have one trust for the house. Now, if you're talking about other assets that you want to put into a trust, then I would say yes. Then you separate them out. You get a second trust maybe for your liquid assets or for other operations that you're doing that are beneficial to your financial endeavors.
Okay. So that answers another question. So, all right. So then this will lead to a kind of a string. Is if I'm opening up a separate trust, let's say for real estate, for that one piece of real estate, and I'm a trustee of another trust.
Okay.
I call it the primary trust.
Right.
So I can go in, I can be either a grantor, a trustee, or a beneficiary. Is that correct?
Yes.
One of the 3 or 2 of the 3.
Yes.
Okay. All right. So basically, let's say for instance, I have assets, liquid assets, and is it possible for me to combine the liquid assets into one trust, or should I have a separate trust for each separate type of asset? And as an example, would be like precious metals or cryptocurrency or other liquid assets.
It depends. I would suggest this. Think about the value of the liquid asset, whatever it is. And if it's not significantly more than the value of your property, then I wouldn't say you need 2. But if those liquid assets are significantly greater than the trust or the assets of the real estate, then I would say yes. Definitely think about a second trust. Keep them separate.
Okay, thank you. And then, and finally, and this is regarding trustees, like professional trustees. Are there benefits, or are there any pros or cons to using professional trustees?
I'm sorry, I missed that. Would you say that again, please?
Okay, with respect to trustees, if I was to lean in the direction of having a professional trustee, are there pros or cons to using professional trustees?
If they're not lawyers and they offer service, I have 2 people here in the U.S. that do that, and they charge a minimum or minor fee, say. So yes, that's fine to have professional trustees. In fact, I think Tons and I have talked about offering a trustee service, and it's probably really valuable. I have to get back to the 2 people that have been thinking about doing that. But for me to offer trustee service and also be writing trust documents, it's a little bit too much work, and I'd rather not do trustee service. But there's nothing wrong with having professional trustee service. If you feel, I would have an interview with them and find out what their fees are, what it takes for them to do that, how much experience they have, etc. But that sometimes works out very well.
Oh, thank you for that. So my last question is regarding certificates, and it's my understanding that there's 100 basic basis points or 100 units
Yes.
in a trust. Can you break down the units to less than one, like a half a unit or a third of a unit, or?
Sure.
Okay. Okay, thank you. That's all I
You're
have.
welcome. You're welcome.
Thanks, Steve.
Whereabouts are you in Australia, Steve?
Just a moment. I have to find him again and unmute him. Sorry.
Right. He can email
I
me.
thought he said New Zealand.
New Zealand. Oh, yeah.
Steve, you're unmuted again. Go ahead.
Oh, okay, thank you. Yeah, we're at the top of the South Island.
Oh, okay. All right. Yes, I have some
Beautiful
friends.
area.
I have some friends there.
I went to the bottom of the North Island, Wellington, but that's as far as I got.
Yeah.
Okay. Anyone?
Okay. Next, anybody else that I have one here from PJ Barr. Banking laws are changing all the time. You're right. And, it's the Federal Reserve and IRS, and they're always trying to figure out ways to get more of your money. Anybody else? Come on, fire away. Standing at the wall.
I'm wondering if everybody knows how to raise the hand.
Let's see. Let me scroll here.
I can ask you this. What is the difference between a trust certificate and a unit of beneficial interest?
Just the name
Okay.
form means exactly the same thing. A certificate is declaring, it's a written certificate that says that you have so many units.
Can you angle your camera down so your face won't slide off the bottom? There we go. Thank you. Go ahead.
That's probably me sliding off the couch. Anybody else? Distributions we receive from the trust. And can't we all pay all our bills and living expenses from the trust? Okay, now that's a good question. It depends on whether you're paying for your personal living expenses, and I would say no to that. So what you're going to do, either as a beneficiary or as a trustee, you're going to cut yourself a check, or the trustee will cut you a check for your personal items. In other words, you don't commingle funds. Do not use trust account for your personal living expenses. Just cut yourself a check and then do whatever you want with it. The whole idea is that you don't want to confuse and commingle funds. Then somebody's going to find out about it and it'll raise a stink and you'll be having to deal with that. Legitimately, so legitimate living expenses, let's say you're an affiliate or you want to talk to people about the trust that you have, then the trust could pay part of your expenses for the car, for gas, or if you use your office to work on trust work, then you could deduct some of your mortgage and use that trust account to pay for some of the mortgage, or basically rent the space that you're using for your trust work or your business work, whatever you have in the trust. If you have a business in the trust, then you can write off significant amounts of expenses that you pay for either in an official office and or if you have a home office. And you can, if you go and your trustees, you and your trustees go out to dinner and you talk about the trust work and what needs to be done, then that's all written off as well. You can be aggressive on writing off any business expenses dealing with the trust.
Perhaps this may be of interest to everyone, Randall, and that is, my understanding is you exchange a property of value into the trust. You don't normally grant it or give it or donate it. You exchange it. And the reason for exchange is that the trust then gives units of beneficial interest, otherwise known as trust certificates, to whoever it is that bequeathed this house or this car or this currency or whatever it may be into the trust. And those units of beneficial interest, 100, 200, however many, make sense, are not really publicly tradable securities, and therefore have no publicly determinable value, monetary value, and that is why they cannot be taxed. Is that something you can comment on?
Well, it's an equal exchange. In other words, you put an asset into the trust and you get so many units of beneficial interest for that asset. And so that's a non-taxable event. So there is no tax event in that case.
Right.
So you're giving your asset for exchange of units, for a beneficial unit from what that asset gives the trust.
Then we have a chat question here. A couple of them. Let's see.
And one from Orlando that says, from unfamiliar with operating the trust, how can we educate as we go along? So one of the things is we're going to do these webinar events, and then you get a significant amount of information in the trust manual, and then I'm always available for consulting. That comes from Orlando. Is there a deed of gift to the trust when you put an asset? Well, no, it's not there's no gift. There's no deed. There's a certificate that's given to you for the value or for however many units of beneficial interest you may have in the trust. If you're the only beneficiary, then and you put your house, and let's say you have some gold coins and you have some cryptocurrency, they can all be put in the trust, and you would get so many units for that assignment. It's an exchange, or I usually use the word assignment. You're assigning the asset into the trust for beneficial interest.
And one of the chat questions you may have seen says, just to get clear, what is the difference between unregistered, irrevocable, discretionary trust done by lawyers and a natural law trust? I think the questioner may be confusing statutory and non-statutory.
Well, whenever you get a lawyer involved, you got to remember that the lawyer works for the state. So even though it's an unregistered, irrevocable trust, it's not free of the state. A natural law trust, you probably wouldn't. The only time you're really going to deal with an attorney is if there's somebody sues the trust, or you need lawyerly advice on how to deal with a particular issue. But My thought would be that an unregistered irrevocable trust done by a lawyer would still be connected to the state. So I'd be a little careful on how you do that.
And it says you talked about transferring units, but can you add or remove certificate holders?
Who would want to do that? No, basically, once the certificates are given out, that's a done deal. Now, if the certificate holder tries to do anything like threaten the trust or complain to take you to court for the fact that they feel they're not getting the amount they deserve, then the trustees can step in and say, "I'm sorry, Mr. Beneficiary, but you're no longer the certificate is no longer valid, and you're not going to have anything to do with the trust." If you threaten the trust, then you're out. If you're a beneficiary. Okay, so I have a question here. How does one assess the number of units to assign the following accounts? Birth certificate. I wouldn't give any units of beneficial interest to a birth certificate. You can't do anything with it. I don't understand bank accounts. Car, never put anything. It's a liability into the trust. No cars, no planes, no boats, nothing like that. Anything that can injure somebody doesn't belong in the trust with your major assets because it's a liability. Now, if you have a valuable plane or car or boat, then you just create another trust for that particular asset. But, unless you're running around in a Ferrari, then I wouldn't worry about putting the car into a trust.
And then this one says, for those of us who are unfamiliar with operating in a trust, how can we educate as we go so as to receive the full benefit of the trust?
Well, there's the trust manual that comes with each document, and I'm always available for consulting, either email or by phone. Just have to set up a time.
Plus the Passing the Buck series, maybe?
Yes, I believe that you have an email from me that has a bibliography on it. If you haven't gotten that yet, I have it written up, but we could maybe put that in a newsletter next time. But they're basically law books. There's the Passing the Buck, of course. There's a couple of more simple, like there's a training book I have that you get when you go to law school if you're focusing on trust law, that to go through all the stages of which we're doing now. And they're basically, I've read it 2 or 3 times. I have it all marked up and it's falling apart, but it's not a lot more in there than what we're talking about during these webinars. And some of the people have asked me about a birth certificate, but it really needs to be a viable. It's not like a piece of paper. You don't want to give a certificate to a birth certificate. It doesn't make any sense. And I don't understand the bank account. You wouldn't sign unit to the bank account other than taking the bank account and taking the asset of that bank account and putting it into the trust. And that would still be for the beneficiary, not for the bank account.
In other words, the beneficiary must be a human being.
Well, no, it can be...
or an institution and an organization.
No, you could set up one of the beneficiaries could be, let's say that there's a 100-year-old oak tree and nobody's taking care of it, and you want to create a little garden around it. Then you could use the trust could give so many units of beneficial interest to somebody or you to take care of that tree. But it's usually for giving it to people or humanitarian projects. Trust can hold equity in a vehicle and not be liable. No, there's no equity in a vehicle because the vehicle is always subject to liability. It's not an asset. What if you have humanitarian projects that need to get going? Absolutely. You can give as many units of beneficial interest to your project as you'd like. If you change beneficiaries, then wouldn't that necessitate a change in certificate holders? Yeah, I think I touched upon that. Well, you're not really going to take that. You're not going to take, if you give beneficial interest to somebody and it's going to stay with that person, you really can't take it back unless the certificate holder, like there's a spendthrift clause in the trust, and if the certificate holder starts to not be able to handle the amount of equity or whatever he's getting from the trust, then the trustees could decide to take that certificate holder away from him, the certificates away from him. But that's in a rare case. And that's just one clause in the trust document that does give the trustees the ability to take the certificate back for the benefit of the other certificate holders. Okay, no more. I don't see any more questions.
Well, there's one that says, "Can we purchase these books from you?" The links to publish them have been in our Brilliance and Commerce newsletters.
Well, I'll make sure that you have another. Mostly they're law books, and they come from law publishing companies that will do that. But I will make sure that you have it again if you don't have it already.
You can send the bibliography to your existing clients, and then for everybody else, we can publish it in the next newsletter.
Sure. The beneficiary dies, then the certificates go back to the trust and they're redistributed. If I did not want to have ownership in my name, can the trust purchase assets? Yes, that's exactly the idea of the trust, is that trust would purchase the asset. That's the whole. So you can take your bank account. You have a significant bank account. You could take that and put it in trust, and then the trust can buy a house or buy any other commodity that would be a better asset for the trust, perhaps.
This question says, a trust can hold the equity of a vehicle and not be liable. True?
No. No, there's no equity in a car. It's still a liability. I don't care how much equity you have in a car. If the trust owns it, then whoever it hits or hurts is going to sue the trust. It's going to sue the owner of the asset.
Yep.
Usually have successor beneficiaries already arranged. Yes, you can have a list of successor beneficiaries. Same with successor trustees. You can do that.
And this question, go ahead.
Could you put your business in a trust from parents to beneficiary children? Of course.
This one from
an asset like the exchange of foreign currency would be handled, not clear up. There's a form in the trust document, and if you don't have it, then you can write to me. If you have our trust and you don't have that form for the foreign currency, you can email me and I will send it to you. It's a one-page form, and it's specifically for foreign currency. And I'll also give an example of how to make it happen. It's quite simple.
So this one says, what if we have humanitarian projects that needs to get going?
Yeah, you'll have to, sure, you can fund it out of the trust.
And you can title it in the trust. Did you answer this one? If I did not want to have ownership in my name, can the trust purchase assets?
Yes. Yes,
Right.
that's the idea, is to have the trust own any asset rather than yourself. It doesn't mean you have to give all your assets into the trust. I'm just saying it can. Let's say, for the sake of it, you have $100,000, and you can take 50,000 and put it into the trust as an asset, and use that for the trust to buy some assets that it wants to, and you can use the other 50 for personal uses.
Mm-hmm.
Hey, I think, Tanzan, do you ever post my email? I think, what did we decide on that?
No,
Right to
no,
you
we,
first.
we handle that through our customer service, and we get questions to you through us to protect you from being deluged.
Yeah. Okay. So let's leave it there. Anything else?
Let's see this. If the trust loans trustee funds to buy a car, is it liable?
Yes. The thing about a car is the trust can lease a car. The trust can lease the car because it doesn't own it, just the lease. And the lease company has the liability, and it has its own insurance program. So yes, that the trust can lease anything. And as long as it doesn't own it, then the liability exists on the leasing company.
And if it loans the trustee funds to buy a car, it depends on in what name the car is titled.
No, no, don't do that.
No,
Don't set,
I'm agreeing with you. I'm saying if it's titled in the name of the trust, we don't want to do that. But let's say in the trustee buys it in his personal capacity, in his individual name.
well, then, yeah, he wouldn't put it in the trust. He would,
Exactly.
yeah, he would, and I wouldn't have the trust pay for the car and put it in my own name, and unless you had enough beneficial interest coming to you to cover that, the loan. So yes, you could do it that way, but I suggest you just lease a car. That if you're going to lease, if you're going to do anything with a car, that you lease it. The trust would lease it.
Or set up a separate trust for it.
I wouldn't, not unless it's a $200,000 car. You just buy it, and or lease, have the trust lease it, or buy it under your own name.
Yeah. Good questions.
Number company that has been rolled into a trust can a purchase of a car. So the car is in the name of the numbered company. Like, yes, a lot of people, what I suggest is that can set up the trust could set up an LLC or any number of LLCs. You get them for $100 depending on what state you're in, and then that LLC can have money from the trust, and then the LLC would be the owner of the car, not you. Okay. Anything else?
What do you think your topic next month is going to be?
I have no idea. It will come about, I'm sure. And there's a few more things to discuss about your trust document itself, but they're minor details, and I may delve into the law books and pull some information out of those that might add to everything that we've talked about. Distribution we've talked about, charitable contribution, no problem. Just talk about anybody that's involved with the trust, it's confidential material. You don't talk about it with anybody other than who's involved with the trust. That pretty much covers most of the three important things are the settlor, the grantor, what the duties are, and the trustees, what their duties and powers are, and the beneficiaries. No need for a foundation if one has a natural law trust. I don't know, a foundation is a different form, and you could do that. And what that would mean is that you're basically separating out your assets. So it's like creating a second trust, but you're doing a foundation. The thing about the foundation is if it's a 501c3, then it's run by the state. If you're going to do a foundation, you want to use section 508. So the natural law trust is tax exempt, and the 508 foundation would be tax exempt. If that's about it, let's wrap it up. Unless anybody else has anything to say. Thank you, Annabelle. Offshore fund, yeah. If you're going offshore, if you want to do something offshore, then there's offshore trusts and offshore foundations, but unless you're doing business offshore, there's no need to do that.
And again, even offshore can be statutory.
Sure, it depends who sets it up.
Yep. What's great about the non-statutory is it can operate just about anywhere in the world and have the same benefits.
Yes.
Well,
yeah. Looks like we're getting lots of kudos here, and I thank everybody for joining us, and I'm looking forward to coming back and giving you some more information.
Yeah, thank you, everyone. And Randall, thank you. And this is some concluding information in case those who came on late didn't catch it in the beginning. Our dates for our webinars, our next one is March 7th, 2018, 4 p.m. Pacific. And if we could go to the next slide. This is just a summary of Brilliance and Commerce. We recited that earlier. House of Freedom International Natural Trust, Liberty Debt Elimination System, and other various things that we come up with. Next. And that's our concluding information for future webinar attendance. Subscribe to the newsletter and hopefully get back to the person who contacted you about this, or to our website if you have that, and phone number 360-200-7521. And if you're not already a subscriber to the newsletter, do so. That'll give you announcements for future events. So thank you, everyone, for participating, your excellent questions, and Randall, your knowledge and your patience.
Oh, it's my pleasure. It's great. So I hope to, if you're already a client, you can drop me a note and with any questions you have. And if you're not, I would hope that you'd seriously think about it and talk to Brilliance in Commerce, and you guys asked some very good questions. So thanks a lot, and we'll see you next month.
Yeah, the contact us link on the home page is where you can reach us through. Okay.
All right,
Excellent.
aloha from
Aloha and mahalo.
Adios.
Adios.